Bill 175 at third and final reading. By the government's own admission, this legislation represents the first major change to how our police services are governed in over 20 years. And yet the government could only allocate 1 hour of House time split between 3 parties to debate the amended bill. A bill of this size and complexity deserves proper debate and consideration, not to be rushed through the legislative process. I can't tell you how disappointed at how anti-democratic this government has been in its blind drive to pass this legislation. However, the worst part of all of this is that among the 250 or so amendments the government introduced, very few of them substantially address the concerns expressed by our police associations and other stakeholders. For the record, the police associations were never opposed to reasonable reforms or improvements to existing legislation. After more than 20 years and new challenges facing policing, there is no doubt that modernization was needed. They, like us, also agree that we need to have an efficient and effective oversight system. However, all that they wanted was for this government's changes to ensure that the tens of thousands of dedicated police officers across our province were treated fairly and that their input and concerns were heard during the drafting process. They met with ministers, they provided detailed briefs, and they trusted in the parliamentary process. They did everything right, Mr. Speaker. But in the end, the government chose to ignore much of their input and decided that they would force through Bill 175 come hell or high water, and here we are. Another troubling aspect of this new oversight position is that not only will the Inspector General be appointed by the Governor in Council, they will also be reporting to the Minister of Community Safety. This opens the door to political meddling in a very sensitive area. I want to read into the record the Police Association's legal submission on this point. Quote, failure to comply with a request direction from the SIU or OPCA in relation to an investigation immediately or as otherwise specified unless it is impracticable is an offence and subject to a fine up to $50,000 or jail. In some cases, what the government has proposed in this legislation may even violate police officers' charter rights according to their police associations. One of the most shocking examples of the government's attack on police officers in this bill is Section 115. This provision would allow the government to demote, fire, or retire officers who are facing disability or dealing with issues like PTSD. Could they sink any lower, Mr. Speaker? This government is even targeting the police officers who are most in need of our understanding and compassion. Why would they do this? To save costs? Well, that's absolute wrong way of going about it. As I was saying, unfortunately, the people who will face the worst consequences of this government's cynical approach to this bill will be our frontline police officers and ultimately all Ontarians, who will end up with less transparency, less accountability, and a demoralized police force, which in turn means reduced community safety. And it's truly ironic that the government had the gall to give this bill the short title of the Safer Ontario Act, when its consequences may actually undermine Ontarians' safety.
The bad part is in the way and in the absolute abuse of power that this government has applied to the debate around this bill. Here are the amendments. There's over 283 amendments that we received less than 24 hours ago, Speaker. It is an affront to this process, to the fundamental process of the passage of legislation, that this wasn't given a due consideration and applied through a lens of democracy. It's irresponsible, it's an affront, and I take offense to it, and anyone who is listening and who understands the ramifications of this would as well. I've got 9 minutes left. 9 minutes in this bill that's going to have consequences for generations in our communities, and I would and will argue that it will jeopardize the health and safety of our communities. To provide one of the following policing functions. Number one is, here's the function. If they can't provide this function, then they are not eligible to apply. Number one, crime prevention. Well, what do you think our current policing complement does each and every day? They prevent crime in our communities. Uniformed, sworn officers who are patrolling are preventing crime just by their very being, Speaker. And when they attend events in our communities and they're shaking hands and taking pictures, guess what they're doing? They're preventing crime. That's frontline community policing. And that's for sale. That's for sale to the lowest bidder. Number two, investigative supports related to law enforcement, including the supports in areas of, one, crime scene analysis is a private provider. CSI. Think of CSI. Think of your worst CSI episode where a bungled private operator messes up a crime scene and that evidence is lost forever because you're paying them $15 an hour. Just think of that. How about another one, Speaker? Forensic identification, fingerprints, DNA. This is for sale to the lowest bidder. Three, canine tracking. You know, those canines are sworn officers as well. The training that they receive is world class, as well as their partners, their officer partners, their human partners. Speaker, we're going to outsource that. Number four, technical collision investigating and reconstruction. That's out the window, out the door. No longer will you have police with decades of experience where they can pull up to a traffic accident and already know the history of perhaps that area and be able to determine potentially from tire tracks what happened and contribute their experience. That's for sale. Breath analysis. That'll be you'll be able to order that. Probably, I don't know, online. That's a 1-800 number. Call up a breath analysis company. Physical surveillance. Okay, so that's now your private operators that are going to provide physical surveillance. Electronic interception, and when I read this one, Speaker, thankfully we had a Ministry of Community and Safety Correction Services lawyer who was in committee yesterday prior to us entering into the time allocation period. So the lawyer was there and he was able to answer some questions when in the hour that we were able to ask questions. So when I got to this one here, electronic interception, it kind of made me think, now who would ever provide that private service? Electronic interception. What does that even mean?
The Russians.
It sounds complex and it sounds technical in its nature and it sounds sensitive. It sounds like something very important. So it prompted me to ask the lawyer whether in the legislation, in this bill or any of the other provisions, whether the government had the foresight to think that we should relegate these service providers, these private service providers, to at least domestic companies, domestically owned and operated, so we could assure there was some sovereignty there, that we weren't exposing our important information and sensitive electronic information to foreign agents or foreign companies. This bill allows foreign agencies, foreign multinationals, to bid on any one of these provisions that you've now opened up to privatization to any jurisdiction in the world. There's nothing that prohibits it. So, Speaker, a massive bill that has been tied to a rocket ship and flown through this building so that either people don't get to fully understand what its ramifications are and they coast into the election, or it's born out of an incompetent government that has no respect for the democratic process and of its colleagues on the opposition that stand and stood ready to assist in good policy and working out the politics of this. But that's not the game they played last night. This is certainly not what we are to should have expected, but this is what we got. And Speaker, it's a shame that this is the process.